All right. Well, we're going to go ahead and get started on explaining what a quick wrap agreement is. So this is a way to bind customers to law enforced contracts through terms of use, and a simple click of a button. Um, a lot of the times, small businesses use this as a way to expedite the customer experience, to make signing up for social media account or accepting the terms and conditions for software licensing or just having to really forego really sitting down with each and every person that's using a website um, by having a simple click of a button for the lengthy and complex terms of use and agreements that are normally associated with statements of work and such. So, what we're really going to touch on today is this really legal? And the answer would be yes, and it's because of two acts. The UETA Act that is enforced by the Uniform Law Commission in 1999 that states that a click-through agreement process or anything that resembles this process is given the same legal effect as any traditional handwritten signature, as well as the InSign Act or the Electronic Signature Act. Anything that resembles an electronic sound, symbol, or process that is attached to a record that is adopted by a person, um, it is shown that anything that resembles any of the above would be considered the intention to sign a record of that variant, especially when presented online. So there's two main cases that really caught like the general public's eye when it comes to click wrap agreements, and we're gonna start with Netscape. Netscape did have a statement at the very bottom of their webpage saying, "Please review the terms and conditions." Um, but there was no option to really agree or disagree with what the terms and conditions implied, and stated that they'd be collecting on each client that interacted with the webpage. So that's what kind of boosted as the original case for why we needed a box to check off on saying, yes, I agree, or no, I do not. Another case that popped up that is very, very important. It also touches on some of the more legal aspects of non-conspicuous, right? Um, Barnes and Noble, when you open up the website, they did not have any like notification when you first like visit that there was terms and conditions that are associated with the website and that are just kind of automatically assumed. There was a simple hyperlink at the bottom of their website um, of every like page. Yes, but there was no clear notice or notification that this was explicitly um, assumed that it was agreed upon. Um, so, because it was a little bit conspicuous and because it was not something that was easily noticeable by each client of the webpage, it got them into a little bit of legal trouble. And that is mainly because, in legal terms, under those two acts, a clip wrap must be seen as easily noticeable, non-conspicuous, and readily available to the user at all times in order to please the court. Um, if the business or corporation that has a clip wrap wanted to fight back on that side, they'd need to provide screenshots and back-end documentation from the website, along with revision updates that they've made to the privacy policy or the terms of service or the guidelines. They would need to provide all of this data and evidence as a term of legal standing that would be able to justify that that click wrap was something that was readily available to each user. Yeah, this is a basic understanding of click-wrap agreements. I hope that you were able to get a basic understanding of how these work and how they can provide a little bit of controversy with small businesses and large corporations as well versus the general public.